So we have discussed about the syllabus first, right? After that, what we have discussed is syllabus of this subject, right? 7 chapters. You're well aware about the weightages of each chapter and importance of each and every chapter, right? After that, we have started with this new, we have understood the paper pattern as well, that fifth and sixth question would be there. Fifth you have to do, sixth they may say one question you have to do, right? Most preferably 6A, right? And we have done with the basics of Payment of Wages Act, right? What was the basics of Payment of Wages Act? That if you are well versed with Payment of Wages Act, you would get to know that what would be the due date of payment of wages, because you have to make the payment on due date or before that. If you make it delayed, you would be subject matter of consequences, right? Second, you know about what should be the wage period. It should not be more than that, right? Generally, we know that everybody knows that, whether you are referring to this law or not, everybody knows over here. India mein there are two kinds of wage payment system is there. Either it would be daily wage, right? That has been paid to the constructor worker or construction worker, etc., right? Or there would be the second payment method, that is monthly wage, right? And the third thing you got to know is what? Deductions, permissible deductions and fines that is allowed under Payment of Wages Act, right? The fourth one is who is responsible to make the payment of wages, right? And the fifth one is what? Consequences and penalties, right? What would happen with you if you will not comply with the law of land, right? Right, students, done. And then what we have studied is students, the definition of employer and employee, right? What is definition of employee? It includes employee and legal representative of deceased employee. That means if something happened to you, your legal hires can sue under this enactment, right? Or second, employer includes legal hire. If something wrong has been done by you, it is going to be suffered by your legal hires, right? Right, students? They have to bear the obligation, right? Now the next definition is industrial or other establishment. Giving you 1 minute time, read it. You have notes, no? You don't have notes? Notes over your mobile, over your phone. Is it there? Or you can take your module, study material, go through with the definition, and I am going to ask questions. Okay. What they are defining, industrial or other establishment. This enactment is going to be applicable on industrial and other establishment. In the definition category, it is being defined. No, students. Just giving you 1 minute time. Just go through and tell me your observation. So understood the definition? Understood the definition? Is it technical or it's simple? Is it simple or technical? What do you understood? What do you understood? See, if I'll go through with this definition, or being a consultant, if I'll show this definition to my client, what kind of reaction he would have? He won't understand anything, right? So if you'll go through with first 3-4 points, can I say that all transportation nature of business would be covered under industrial establishment? Can I say that, students? Yes. In a very simple manner, can I say that in first 3 lines they have includes airways, roadways, or waterways, right? So can I say that all kinds of transportation would come under the definition of industrial establishment? So if you are owning a transportation organization, or you are into a transporting business, you have to comply with Payment of Wages Act. Can I say that, students? Right? Second, I think they have included all public utility services like water supply, electricity supply. Can I say that all public utility service provider would come under the definition of Payment of Wages Act? So if you are a public utility service provider like Adani Electricity, like Tata Electricity, Tata Power, right? Like governmental state electricity boards, right? They have to comply with the requirement of Payment of Wages Act. Can I say that, students? Right? Right, students. Next one is what? Next, manufacturing sector will come. right? Manufacturing sector will come, because shipping would come under waterways, na, right? Now, what all workshops, that is manufacturing workshops. So, can I say that if you are owning a manufacturing organization which is into manufacturing of anything, right? Whether it is textile or it is, utensils or whatsoever you are manufacturing, chemical manufacturing industry, right? If you are into a manufacturing business, this act is going to be applied on you, right? Can I say that, students? Later on, all public utility and any other organization that has been notified by the appropriate government, means state government will determine whether the service sector would come under this definition or not. And we know that service sector would come definitely under this enactment, right? Because India ki GDP mein the maximum proportion that is being contributed is by service sector, right? So can I say that if you are owning a commercial nature business organization, right? Whether it is transportation business, it is mines or quarries or something, right? You are into manufacturing sector, right? You are into public utility service provider, right? Or you are into any other organization which is being notified by appropriate government, generally a service sector as well, right? You have to comply with the requirement of what? Payment of wages act. Can I say that, students? Rather than getting it complicated, why not to understand the basic understanding, right? Right, students? So can I say that now you can divide what? The transportation include waterways, shipping business, vessel, right? Right, students? Now excluding two organizations, they are saying that if you are into a transportation business for military, naval and air forces, or you are into a transportation business because of civil aviation department of government of India, they are having their own payment terms and condition. You need not to comply with the requirement of this enactment. Done? Done, students? Is it simple or a complicated thing? Now is it simple? Got my point? So after going through with the definition, I understood that not only the employer, their legal representative has to be complied with the requirement of this enactment. Not only the employee, the right lies with the legal representative of the died employee, right? And we got to know that all kinds of industrial establishment into manufacturing, into mining, into transportation, right? Have to comply with the requirement of this enactment. Is it clear, students? Got my point? Will you be able to write? Done. Proceeding further. Now they are defining the term wages. What they are defining, beta? They are defining the term wages. Now, what would be the relevance of the term wages, beta, over here? What would be the relevance of the term wages over here? Tell me. What would be, what would be the relevance of wages over here? So, what would be the relevance of wages over here? If, so, what would be the relevance? For this enactment only. Why they are defining wages, beta? Think logically now, why they are defining it? So can I say that they are defining it for the sake of understanding that whatever would be included over here in the definition of wages has to be paid according to the Payment of Wages Act. And if something is not included in the definition of wages, you need not to follow Payment of Wages Act for that, right? Right, students? That would be the relevance, no? Right? See, I am telling you, a profit-based bonus is not the part of wages over here. So suppose my employee is working for me and I am saying that if you will generate a profit of 20%, I am going to pay you 2% extra bonus. But I am going to pay you annually, I am not going to pay you monthly. Do I am contravening the provision of Payment of Wages Act? No, because bonus is not the part of wages. But if I am promising him to pay the bonus according to his salary, it would be the part of the wages. And I am saying that I am going to pay you salaried based bonus, okay, but I am going to pay you annually. Now, am I contravening the provision of Payment of Wages Act? Yes or no? See, if bonus is a profit based bonus, it is not the part of salary or wages. But if the bonus is the part of the wages, it is the part of the salary. Is it clear? Or wages. So if I am paying you as an employee monthly, I am paying you bonus on your salary, and I'm like, I'm going to pay you annually, I'm not going to pay you monthly. Am I contravening the provision of this law? Yes or no? Yes, because it is the part of wages, right? Right? Understand again. Got my point? See, if something is the part of wages over here, I have to pay it according to the terms of Payment of Wages Act, right? If something is not the part of wages over here, I can pay it on my own convenience, right? I need not to follow this law, right? I told you profit based bonus is not the part of wages over here. Can I pay it on my own convenience? Yes, because on that term, Payment of Wages Act would not be applicable, right? But if something, salary based bonus is the part of wages over here, can I pay it on my own convenience? No, because on that Payment of Wages Act will be applicable. Is it simple? See, I'm not teaching you, I'm not telling you the basic definitions. I'm trying to make you understand how this definition works, right? Right, students? Otherwise, what is the need and necessity to, if just I have to make a plain reading? Got my point? Is it clear? So what they are saying there is, see, here it is written like wages includes all remuneration that has been payable under any award, settlement or of parties or court. Means if generally see, but whenever it comes to payment of wage is being determined by a contract, right? So contractual wage would come under the definition of wage, right? But if there would be a dispute between employer and employee, they will approach a labor court, right? And labor court will determine that how much you have to pay to the employee. So that will even come under the definition of what? Beta wages. So wages may be determined by the contract or it may be determined by the court, right? It would come under the definition of payment of, it would come under the definition of wages, and you have to pay according to the law, right? Got my point? Now they are saying that even overtime work would come under the definition of wages. So if someone has worked for overtime, you have to pay that overtime payment according to Payment of Wages Act. Got my point? The third thing is even leave salary, etc. Now additional remuneration under terms of employment, bonus or any other term. But bonus should be what, beta? Bonus should be employed bonus. It should not be profit based bonus, right? The fourth one is any sum payable on termination of contract. Means if you are removing an employee, right, and you are paying him termination compensation, even that would come under the definition of wages. And the last one is what, beta? Any sum entitled under any scheme frame under any law for the time being in force. So how many things are being included in wages, beta? 5 things. The first one is contractual salary or contractual wages or wages determined by the court of law, right? The second one is what? Overtime remuneration or leave wages, right? The third one is bonus, but not a profit based bonus, it should be salary based bonus. The fourth one is right, and the last any other thing. See, I have made a formula in the down: salary plus overtime plus bonus plus termination payment plus other legal entitlement minus bonus or non-salary benefits, right? What is non-salary benefit? If suppose, see, over here in India, all sales employees, even over the world, all sales employees are being appointed with 2 terms. The first one is you will get the fixed monthly payment plus you will get the incentive. So you are going to get the sales pay incentive. So incentive can be paid quarterly, half yearly, annually, right? Because it does not come under the terms of wages. Got my point, students? Is it clear? Now employer's contribution means PF contribution need not to be on monthly basis, right? It should not be according to Payment of Wages Act, right? Now travel allowance, it can be reimbursement, right? It can be paid quarterly, half yearly, annually, monthly, fortnightly, daily, right? No Payment of Wages Act is going to be applicable on it, right? Special expenses. What is special expenses, beta? What is special expenses? That you have to bond because of your nature of work, right? Because of nature of your work, right? Like if I am working in an organization where a particular dress code has to be followed, so I have to bought 3-4 pairs of those dresses or uniform in order to work in that organization. So whatever would be the cost of stitching and buying the clothes will be taken care by the organization, right? That is called what? Special expense, right? Or gratuity. So overall, how many things are included? You just learn the inclusion. Exclusion need not to be learned, because other than these 5 things, if something will come up, need not to be paid according to the Payment of Wages Act. Is it clear? So all things 5. The first thing is what? Contractual. See, be very specific. It can be a contractual salary or it can be court determined salary or wages, right? The second one is overtime payment or leave payments, right? The third one is bonus, but not a profit based bonus or incentive based bonus. The fourth one is termination payments, right? When you are terminating the employment of an employee, you have to pay the termination compensation on the basis of Payment of Wages Act. The fifth one is other legal entitlement notified by the appropriate government. Got my point, students? Is it clear? So how many things has been done? If I am well versed with this law, I know when to pay, how to pay, right? By whom to pay, right? What would be the legal consequences and what should be the wage period, right? I know not only the employer, even the legal representative is not going to be spared, right? Not only the employee, even entitlement pass on to the legal representative, right? Means succession is possible, right? I know all kinds of industrial establishment, whether it is transportation organization or it is a manufacturing organization and mines or public utility service providers, right, would come under the definition of organization, right, or industrial establishments, right? It does not include transportation services by and the transportation services of civil aviation, right? Right, students? Is it clear? And the last thing is what? Whatever is being included in the definition of wages has to be paid according to the terms of Payment of Wages. If something is not come under the definition of wages, it need not to be paid. Suppose I have joined one organization in the month of September, 1st September. They told me certain goods or certain accessories or certain specific requirements that I have to comply with. Rahul, you have to take certificate of practice, you have to take that, you have to take this, and I have taken everything. Now I'm claiming them just get cleared by the September end with my first salary. You are going to pay my salary by 5th of October for the September month. Now you have to pay all the expenses borne by me on 5th October only. Otherwise I am going to sue against you under Payment of Wages Act. Can I sue against them? Yes or no? Why no? Why no, students? It's special expense, right? And special expenses pay which is not applicable is Payment of Wages Act. Got my point, students? Is it clear? Is it clear? Suppose a sales employee is there. He was getting 2 kinds of remuneration. One is fixed payment and another one is sales based incentive, right? Every sales pay he is getting 3% incentive, right? Now the organization has come up with the new policy that they are going to pay the incentives only on Diwali, not on any other occasion. So will their payment policies are in terms of Payment of Wages Act? Yes or no? Payment of Wages Act. Is it according to the terms of Payment of Wages Act or not? Yes, it is on the terms of Payment of Wages, because it is a sales based incentive, right? And sales based incentive pay, what is not been applicable is payment. Got my point, students? Is it clear? Yes. Absolutely clear. Done. Now proceeding further. I have made one case study as well. It's based on that only, profit sharing scheme. See, Ravi, an employee, received a bonus under a profit sharing scheme. If he is getting on profit sharing scheme, there is no Payment of Wages Act will be applicable. If it would be part of salary, then Payment of Wages Act will be applicable. Right? Right, students? Now, who is responsible to pay the wages? Now, I am teaching you section 3. What I am teaching you is section 3. Tell me the answer. Who is responsible to pay the wages? The employer. And if the employer will die, then legal repeal. And if the employer has not appointed, he is not the immediate employer, he has not appointed the employee, he has appointed the employee through contractor, who is responsible primarily primarily contractor. But if contractor would fail, then who would be responsible, beta? Logically, employer. Got my point? But the primary duty to discharge the wages lies with the contractor. The secondary duty lies on, right? Means in the court of law, what you will have to prove, you have worked for the employer, but the contractor is not making payment. Now there would be a dispute between employer and contractor, right? So in that case, the court may pass an order that employer, as of now, you pay it and recover it back from the contractor. The employee should not suffer. Got my point, students? Which section I am teaching you is section 3. So what section 3 is saying, that the employer is responsible for paying all wages required under this act to the employees, right? Logical. Now in case of factories, who would be the employer? Not the owner of the factory. The occupier or the manager of the factory will be treated as what, beta? Employer. Got my point? If your organization is what? Factory. Then who is responsible to pay the wages is the manager of the factory. If you are having an industrial establishment, so ultimately the person who is having ultimate control of the business organization will come under the definition of what, beta? Employer, right? If you are belonging to the railway administration, then the railway station ka that concerned manager, right? Station master, right, students? In case of contractor, who is responsible, beta? The contractor himself, right? Got my point, students? So what is section 3? Explain section 3 and its practical relevance. What is the practical relevance, beta? What is the practical? Suppose I am owning an organization, okay? I am having a registered company. Now I cannot take care of everything. I am taking care of the funding, right? I am putting my money in the business. Now I have appointed employee for everything, right? For HR, I have appointed HR manager. For other things, I have appointed other employees, right? Now my certain employees or HR department has made fault under Payment of Wages Act, and they have not made the payment according to the requirement of Payment of Wages Act, okay? So now the employees are willing to sue against me, okay? Although they are getting the salary from the HR department, but they are willing to sue against me. Then can they sue against me? Yes or no? I didn't told that I am owning a company. I am saying that I am having, say, ordinary partnership firm. Can they sue against me if I am having a partnership firm? Say I am having a proprietorship firm, okay, in which I have appointed you guys as an employee, okay, and I have hired one HR manager who is taking care of your appointment, your employment contracts and everything, okay, and every month he is paying you by the 5th of every month. This month he has been passed and he hasn't paid the dues to you, okay. Now you guys are suing against the owner of the firm. Can you file a suit against me? Yes or no? Yes, sir. How? Tell me. Tell me with logic.
Owner is responsible for the
What? But I have delegated my responsibilities, no? What? What? So if I have delegated all my duties to him, no, he is competent enough, that is why I have delegated him. So will he be responsible primarily or I would be responsible primarily? Have you ever heard about the delegation of power? Delegation of power ka concept, have you heard at any time? What do you mean by delegation of authority? Transferring the transferring the सोच के transferring the you can delegate only the powers, you cannot delegate the responsibility. That is the concept of delegation of power. What I can delegate you is my authority, what I cannot delegate is my responsibility. So even if I am owning a company, or if I am owning a partnership firm, or if I am owning any entity, if I am having the ultimate control of my organization in my hand, I would be treated as an employer and you can file suit against me. Got my point, students? So primary and foremost responsibility lies with the owner, not with the HR manager, because whatever I can delegate is what? My powers, but what I cannot delegate is my responsibility. Got my point, students? Is it clear? So even if there would be a contravention of labor laws, can employees file a suit against company secretary of the company? Yes or no? Yes or no? Because according to section 205 of Companies Act 2013, it is the statutory duty of the company secretary to comply with the norms applicable on companies, right? So statutory duties are there. Company secretary would give justification that I have delegated my responsibility to HR department. Still, who is answerable is company secretary. Got my point, students? Is it clear? So this is the practical relevance, that who is responsible to pay the wages. If it is being factory, the manager will be entitled. If it is the governmental department, the concerned department. If it is a railway station, then the station manager, right? And if nothing has been specified, then the person who is having the ultimate control of the organization will be responsible to make the payment of wages according to the Payment of Wages Act. Got my point, students? Is it clear? How many definitions has been done? Employer, employee, energy, students. First one is employer. The second one is employer. The third one is industrial establishment. The fourth one is, the fifth one is who is responsible to make the payment of wages. Section 3. Right? Right, students? Is it clear? Now, fixation of wage period. We know that what is the wage period. If I would not teach you section 4, even you know that, right? No wage period should exceed more than a month, right? No wage period should exceed a month, right? Means maximum permissible wage period over here in India would be 1 month. Can it be 7 days? Can it be 7 days? Can you pay weekly wages?
Yes, sir. Yes, sir.
Think about it. Can you pay weekly wages?
Yes, sir.
Because it is less than a month, right? Can you pay fortnightly wages? Yes, 15 days, right? Can you pay daily wages? Yes. Can you pay every 5 days mein wages? Yes. Can you pay wages on 1.5 month? No. Got my point, students? Can you pay profit based bonus on half yearly basis? Can you pay profit based bonus on half yearly basis? Who said no? Who said no? Why?
Sir, it is like incentive based, so profit based.
Profit based bonus is what? A bonus that is not a part of salary, right? It has been clearly written. Now, if it is being the part of the salary, not calculated based on sales or profitability, it is part of salary. Otherwise, it is not. So it can be paid half yearly, right? Right? Can special expenses be paid every year? Why? Because it's not the part of wage. Got my point, students? Is it clear? So, section 4. Manageable as section 4. Manageable, students. First thing is, what you got to know about this law? What all topics will be clear if you will go through with Payment of Wages Act? Tell me. The first thing, the due date of making payment of wages. The second thing, the wage period. The third thing is, the fourth thing is, who is responsible is provided in which section? Right, and the fifth one is what? The penalty. Got my, the wage period is defined in which section? Got my point, students? Is it clear? Now 5. Fifth is very, very important. Okay, time of payment of wages, that is section 5. Okay, now section 5 is stating that if your factory or establishment, that is industrial establishment, right? If in your industrial establishment number of employee is up to 1000, is less than 1000, is less than 1000, means if you are having an organization having an employee less than 1000, you have to make the payment of wages within 7 days after the wage period ends, means next month ka 7th, right? 7th of the next month, right? You have to make the due date of payment of wages would be what, beta? 7th of the next month, right? Right, students? If the number of employees are less than, I think I have seen almost all the organizations are having number of employees less than 1000, right? Only big organization would have 1000 or more employees, right? Right, students? As more number of employees are there, more outlay will be there, more payment has to be done, more funding would be required. So they are being provided with 10 days, right? How many days is being provided to them? 3 additional days, right? So if Reliance, it comes to Reliance or Tata, by what date they are just clearing their payment would be? By 10th, right? Maximum by 10th. They can make the payment on 2nd, 3rd, 4th, 5th, 6th, 7th. Whenever they want to do, they can get it done, right? But beyond 10th, they cannot stretch it, right? And when it comes to small organizations like Arivuplo, they are having employees less than 1000, right? By what date they should make the payment? Maximum by 7th of the next month, right? Wage period end होने के कितने? That is 7th day पे, right? Right, students, manageable. Now, in case of dock, wharf, jetty or mine worker, when their loading or unloading has been completed, means when their assignment or duty has been completed, okay, within 7 days after the final loading or unloading. Got my point, students? How many points are there? 3 points. The first one is what? If you are an organizer, what? First one is what? If the number of employees in your establishment. If I would say that Payment of Wages Act is only applicable on corporate organization, true or false? The Payment of Wages Act is only applicable on corporate organization, not on non-corporate. True or false? It is applicable on industrial establishment, right? Industrial establishment may be a proprietorship firm, it can be a partnership firm, it can be a cooperative society, it can be a company, it can be a limited liability partnership firm, right? So while writing the answer, never use the term company, use the term establishment. Got my point, students? Is it clear? So what they are saying that now section 5 is stating that 3 things. The first thing is what? If you are an organization or establishment where the number of employees employed in a financial year is up to, less than 1000, pay the wages by the 7th of the next month, right? On or before, right? On or before 7th of the next month. Otherwise pay on or before 10th of the next month, right? Next wage period. We should not write the month, right? It can be 15 days, it can be a week, right? So for wage period, right? Right, students? The third one is, in case of any organization dealing with what? That is jetty, mine worker, etc. Once the assignment, that is loading or unloading, has been completed, the wage should be cleared within 7 days. Got my point? And here they haven't used the term working days. They are telling 7 days, right? 7 days means including non-working days as well. Got my point, students? Is it clear? Now, if you have terminated the employee, right? On termination, I told you how many days will be available, beta? See, here they have written 2 working days. So if an employee is being terminated on Friday, he is eligible to get the payment by Tuesday, right? Right, students? Because here they have written what? Working days, right? On termination, within how many days you have to make the payment is? Within 2 working days, right? excluding holidays because it's working days, right? Now termination due to establishment closure. What is establishment closure? Liquidation, right? Winding up or liquidation. Again, you have to make the payment within 2 days after closure, including excluding holidays, means 2 working days, right? Right, students. Now government can exempt certain category of establishments, and general rule, wage payment should always be made on working day. The wage payment should always be made on working days. So working days means if the due date of payment is coming on Sunday, which is not a working day, you have to make the payment on preceding day, Saturday, right? You cannot exceed it to Monday, because if you will extend it to Monday, it will be a contravention of section 5, right? Because that will become what, beta? Eighth day, not the 7th day. Got my point, students? Is it clear? So what we have understood is till now, if I would act as a labor consultant, I would suggest, if some client will come to me and ask me that, Rahul, I have to make a payment plan because I have to bear certain working capital expenditure every month. I have to make payment to my employee. I'm planning, like, my all employees are ready and they are okay with that I'm going to make the payment on 15th of every month. I would stop him over there, right? I would say, no, don't get into any contract or commitment or any kind of written arrangement with your employee. Your employee even can sue against you after that arrangement, right? Because your agreement is in contravention of Payment of Wages Act, because anything that has been written in a contract cannot override the law, right? Right, students? He would insist, no, Rahul, I am having trust. I know that my employees are not going to sue against me. I would say, see, even if they would not sue, if the inspector of Payment of Wages Act would come and check your registers, that when you are making the payment of wages, you would be ruled out for contravention of Payment of Wages Act. So one more principle I got to know that is what? if even all employees are agree for the contravention of this enactment, right, with a written arrangement or agreement, the agreement would not prevail. What would prevail is the law. Got my point, students? Is it clear? Is it clear? Taking 2 minutes pause, go through with every provision. If you are having any doubt, then ask, then I'll proceed further. Okay, students? Is it going fast or is it going slow? Or you are getting everything, you are happy? Few faces are happy, few faces are like stressful.
Sir, in reality, these laws, are they followed or not, sir?
Logically think about it. Can you stay without complying with the law? Do you have any kind of sustainability assurance? See, if you are having two-wheeler and you are riding it without license or without proper documentation, one or some other day you are going to be caught by the police, right? What would be the consequences in that case? Either you are subject matter of fine, and if you cannot pay the fine, then in that case you would be subject matter of imprisonment, or your bike would be seized, right? So can you survive without complying the law? Can you sustain a healthy life, a peaceful mind without compliance of law? Answer would be no, right? So do you think that these compliances would not be done? If you are not paying to the employees on time for 1 month, 2 months, 3 months, 4 months, 5 months, 6 months, or for a year, right? Once you will be caught, right? What would be the consequences? Will it be in your favor? Will your organization will be sustainable or what?
It is within 7 days. So what if I pay with 18th on date and if all the employees agree? Because one of my
I told you very clearly. I have given a clear example.
in reality, I'm asking.
I'm giving you a reality based example. Suppose a lady will marry a man on a condition, on a paper, that if she is marrying to him, she cannot enjoy her right to freedom of speech. Will that contract, arrangement, or agreement between husband and wife survive, or it would be a subject matter of legal action? Tell me. Can you take away the fundamental right of freedom from a person because she is getting into a marriage with you? You have get into an agreement with a lady that get married with me, and after marriage you cannot get into any kind of employment or working, although these kind of oral arrangements are being happening over here in India, right? But can you stop a lady to right to exercise her right to work? Cannot, right? Because law would always supervene the contracts, right? So even if employee would say, no, no, Rahul, I don't have any problem, pay whenever you are having money, don't pay now, I'm not worrying about it. The inspector will come, they'll check the documents, and if they'll see there are pending wages that has not been cleared according to this law, you would be subject matter of penalty and punishment. Got my point? No contract in this world can survive which is contravening the law. Got my point, beta? What termination?
Termination.
It's just a clause, beta. Suppose,
I have a doubt.
yeah, ask.
Now, what if the termination is on mutual consent or
Whatever condition is. What is termination, beta? What is termination? You're dismissing the employee, right? You're saying that don't come from tomorrow. I don't like you, right? You discontinue my employment. You're not worth of paying the salary, right? I don't want you in my organization. You are saying that, right? You have removed him. Now he's having no employment at all because of you, right? Now he'll ask for the final dues. No, right? Will he ask or not? He would ask, right? He'll contact the HR department. He'll say that do my final settlement, right? In that case, the settlement amount you have to pay by 2 working days. Got my point? Is it clear?
mutual consent also you have to
Whatsoever. Generally, terminations are either arbitrary or mutual. Generally, it should be mutual only, right? If you are terminating someone, that will lead to what? Legal dispute, right? Right? So better is what? To comp off and settle, right? Otherwise, he can file a suit against you. It's an industrial dispute, right? Got my point, students? Getting everything? Online students, please interact. Getting everything? Read and review, beta. Is it interesting or boring, labor law? If you are having any doubts, feel free to ask, okay? Manageable students. Section 1 is basics and applicability and object of this act. Section 2 is definitions, where we have gone through with 4 definitions: employer, employee, wages, and industrial establishment, right? Then the section 3 is what? Person who is responsible for the payment of wages. Section 4 is what? Wage period. Then section 5 is? 5 is? Very important section 5 is, right? That is due date of making payment of wages. How many days? 7 days, 10 days, 7 days, 2 days, 2 days. And in not applicable on certain governmental establishment as notified by central government, as notified by the appropriate government. And the last one is wage payment should always be there on working day, right? Right, students? Manageable. And if the due date is a non-working day, take the preceding day, right? Manageable, students. Now section 6, wage payment method. So now tell me, what would be the wage payment method nowadays? Nowadays every payment we are making through digital payment made, right? Right, students? Every day, when it comes to payment of wages act or any labor laws, no, students, you are going to get the discrepancies on state by state. Because I told you very clearly, when it comes to law can be divided into 2 parts. The first one is act, the second one is rule. And rule making power is there with the administrative authority, right? And here the rule making power is there with the state government. With whom the rule making power is there, beta? We are only studying act, we are not studying rules, right? Rule making power is there with the state government, right? So can I say that payment of wages act may vary according to state to state, right? Can I say that, right? So as of now, I know recently the Delhi government has come up with a very clear instruction. Now the cash payment of wages is not at all allowed. You can only make digital payments, okay, by using IMPS, NEFT, RTGS, or UPI, okay. So digital payment is being mandated in Delhi, okay. But here it is clearly written that wage can be paid in cash as well, right? It can be paid in cash, it can be paid through banking channel, it can be paid by check, right? So cash is allowed, but in your state it may not be allowed according to state rules. Got my point, students? if Maharashtra state has come out with a clear notification that every now and then we cannot check the cash payments, we don't have sufficient number of inspector every time, they cannot come and check the organization's record, better to keep it in a banking record, right, by making a digital payment. So now you have to make the payment through digital mode. Got my point? Otherwise, can the payment of wages be made in cash? Answer would be yes, but subject to state ruling. Got my point, students? Is it clear? Which section it is? Section 6. Can you use discriminatory condition like you are making payment to few employees in cash, few employees in check, few employees in digital method? Answer would be yes, you can. Here no restriction has been written, right? But do you think that an organization would adopt such kind of discriminatory condition and create a problem for themselves? Answer would be no, right? Right? But sometimes on urgency, if you have made the payment of wages on cash and certain employees is being paid digitally, will it be a contravention of this law? No. Got my point, students? Is it clear? Which section we have done is section 6. Online students getting everything. Now going ahead with section 7, which is very, very important. After section 5, what is important is section 7. Okay, 7 is all about what? Deductions, right? Permissible deductions. What I'm teaching you, beta? Section 7. What all you can deduct from the due salary, right? From due wages, what you can be, you can deduct. So first they are saying that fines. What you can deduct is, beta? Fines. Now, but can I say that if you are imposing any fine, it need to be duly notified to the employees, right? Can I say that fine is a subject matter of organization's own policy? Can I say that? Beta? Do you think that fine is something that is going to be defined by law? Answer would be no. An organization, in order to determine, see, today I came and I am conducting your lecture. I have told you about certain set of rules. That is being made by me, right? That is not being made by law, right? So if you are not doing it, if I am imposing any fine, can I say that fine should be properly communicated to the employee in advance, right? If you are saying that today you are not doing that, I am charging this fine. You cannot put any fine as per your own convenience, right? Fine should be pre-notified. It is a subject matter of what, beta? Uniform policy, right? It should be subject matter of what, beta? Uniform policy. You cannot put like, if you are coming 15 minutes late, I am going to give you half day ka payment, and if you are coming 15 minutes late, I am going to deduct 1 hour ka payment. Will it be possible? Will it be possible? No. No discrimination is allowed. It should be a subject matter of policy and it should be uniformly applicable to all the employees. Got my point? And it should be pre-notified. Got my point, students? Is it clear? Which section I am teaching you is section 7. What section 7 is saying that, Rahul, being an employer, what amount is allowed to be deducted from the salary of your workers, right? Or the wages of your worker. The first thing that can be deducted would be fine, right? But fine should be pre-notified. It should be a subject matter of policy and it should be uniformly applicable. Logical, students, right? The second one is absence from duty. Logically, if you are not coming to the organization for work, your leave would be noted and the leave payment will be deducted, right? Right? Absence from duty can be deducted without any doubt, right? Without any even pre-notice, right? It is implied that if your organization is working for 25 days a month and you are working 15 days, you are going to get the payment for 15 days, right? The third thing is damage or loss of goods entrusted to employee. Here all marketing employees, all chartered accountant, company secretary working in an organization is being provided with laptop, tab, mobile phone, right? If you are using someone's property, you have to take care of it as your own, right? If you would cause any kind of damage to that property, that is subject matter of recovery from your salary, right? Which section I am teaching you is section 7. After reading through with section 7, we will got to know that what all amount can be deducted from the salary. So what is permissible to be deducted is fine. The second one is absence from duty. The third one is anything illogical? Is anything illogical till now? No, na. Everything is practical, right? If the fine is being duly communicated, right, it is going to be deducted. If you have done something which is causing the imposition of fine, right? The second one is what? Absence, that is, even if it is not communicated, it is subject matter of deduction. The third one is, even if it is not communicated, it is subject matter of deduction. But can I say that even for calculating the damages, the organization should have a strict policy, right? Now, if you will damage my laptop, I'll charge 30,000 from you and 20,000 from her. So how that 30 and 20,000 has been determined, there should be a valuation norm for the same. There should be a policy measure for them, right? Right? If I am working in an organization, they have provided me with an iPad and I have got it damaged. Now they are saying that, Rahul, we are going to deduct 50,000 from your salary, and same time my another friend who is working in an organization is being deducted for only 15,000 when he lost that tab. So can I say that I can file a suit against the employer, that on what basis they are calculating the damages? There should be a proper policy for them, right? So the court would ask, the labor court would ask, tell us the policy on based on which you have determined the amount of loss, right? Right, students, is it clear, logical enough? The fifth one is, if any advances has been paid, that can be deducted. Logical, students. If any advance amount has been paid, you came to me and you are asking that, sir, please give me 2 months ka advance salary, and I have paid it, so definitely I am going to deduct it further from your wages only, right, students? How many things are there? As of now, 5. Which section I am teaching you is section 7. The first one that can be deducted is fine, subject matter of policy and with uniformity. Damages, subject matter of policy and uniformity. 3 things need not to be communicated. The first thing is what? Advances, absence from duty, and the third thing is what? Damages need to be policy matter. The third, I didn't go through with it, is housing facility, right? If I am providing you with house or with servants or with some other amenities, right? Water facility, right? Or electricity facility. So whatever expenses I am born to maintain your household expenses, right? I am entitled to deduct it, right? So how many things are there, beta? 5, out of which 2 is a subject matter of policy, 3 is a logical. The 2 which is a subject matter of policy is what? Fine and damages. And 3 things is not a subject matter of policy. The first one is advance salary, absence from duty, and amenities. In case of amenities, what kind of policy, beta? In case of amenities, whatever amount is being paid by the employer to the third party, if I am paying rent for you, I'll deduct that rent from your salary. What kind of policy is required? No discrepancies will be there, right? Right, students? The next one is what? Repayment of loan from welfare trust with interest. So if suppose you are having your PF with me, okay, and now you have taken loan based on that PF, so that amount that has been taken as a loan including interest can be deducted from your salary. Got my point, students? So PF loans and their interest. Got my point, students? Which section I am teaching you is section, what is the practical relevance? Those all 10 things that has been written over here can only be deducted from the salaries or wages. Other than these 10 points, nothing can be deducted from wages. Got my point, students? Next one is subscription to and payment of provident fund advances, right? If you have subscribed for PF, then your PF contribution can be deducted. Logical, right? Have you gone through with income tax? No, na? 12% PF is being deducted, okay? So 12% is being deposited by employer, 12% is being deposited by employer. So every month I am going to get 88% of my salary, right? 12% will be deducted for PF. Got my point, students? How much PF is being deducted generally? 12%. Got my point, students? Next, income tax, right? TDS will be deducted, right? What would be deducted? Logical, students, right? Next, payment to approved cooperative society. If the organization has took any kind of insurance for you, that insurance premium will be deducted, insurance contribution will be deducted, right? If your employee has bought ESOPs, you know na ESOPs. What is ESOPs? I'm not asking full form. What is ESOPs? What is ESOPs? Whenever what? Well, you're going in a right direction. Actually, for loyalty. Tell me, what is ESOPs? Not on free of cost basis. Okay. Any example? Sweat equity cannot be on free of cost basis. Who told you on free of cost basis? Nothing can be given on free of cost basis. Because whenever a company is coming out with a public issue, they are coming out with a, now what is public issue? What is public issue? When the company is coming out in front of the public and asking that put your money as a capital in our business, right? So whenever company is coming out with a public issue, it will get into revaluation. That it is a very important event for the company. So company is going to be evaluated by the public in large, that on what valuation they'll take the shares of the company. So in that case, as the company is going to get overvalued, okay, because of the successful public issue, company is coming out with ESOP pool. Every public issue is having around 5% reservation for employees. Whenever the company is coming out with a public issue, they are coming out with 5% reservation for employee, that in this public issue, we are reserving 5% ka portion for employees, and those employees who are interested can file an application under reserved category. You need not to stand in the queue of public. Got my point? So at that time, the prices are low for the employees and they would be categorized as a reserved category. So they'll get confirmed allotment. Generally over here in India, every public issue is a subject matter of oversubscription. 10 times, 20 times, 30 times, 50 times. So if you are applying as an public, you are not going to get the allotment. But if you are applying for ESOPs, it is sure that you are going to get the allotment. Got my point, students? So employee will get the benefit of what? Overvaluation. Got my point? Is it clear? So if you have subscribed for ESOP, what you have to do is you have to make the payment, although concessional price, but you have to pay, right? So as you have to pay that concessional price, that can be deducted from your salary. Got my point, students? Is it clear? So how many things can be deducted, beta? According to section 7, logically 10 things can be deducted. 2 need to be justified. Other 8 can be deducted based on the actual prices, right? The first thing that need to be justified is fine. The second thing that need to be justified is them. Otherwise, then income tax, EPF contribution, insurance contribution, ESOP values, or amenities provided, right? These all can be deducted based on actual cost, right? Right, students, is it clear? Which section has been done as section 7. Done. Section 1, applicability, right? Section 2, tell me the names of definitions. Sir can explain 4th and 7th point. 4th is like if an employee is working over here, suppose I came over here from Mumbai and I am residing in Bengaluru. So definitely there is certain costs that need to be borne for my residence, right? So if any amount that has been borne by Arivu Pro for my residential facilities, they can deduct it from my final remuneration. Got my point, students? And 7th is if you have subscribed for any provident fund or you have taken any advances on provident fund, okay, both the amount can be deducted from your salary. Got my point, students? What is section 2? Definition includes employer, employee, wages, right? Then the further thing is section 3. Section 3 is what? Who is responsible for making? Who is responsible? The person who is having ultimate control of the organization. Then next 4 is what? Wage period, and wage period should not be more than 1 month. Then section 5 is time period is 7, 10, 7, 2, 2, not applicable on certain governmental establishment, and working day base pay the wages, right? Then section 6 is what? Wage can be paid in cash or it can be paid in kind. It can be paid by using checks and other digital payments, right? Right, students? And the last thing is what? 10 permissible deductions from wages. Got my point, students? Is it clear? Online students? Now, one case study: Priyanka's employer provides her with accommodation and utility as per part of her job. A portion of her wages is deducted for these benefits. Can he deduct it? He has provided with to her with house and house related amenities. That the actual expenditure can be deducted or not? It can be deducted, right? Right, students. Manageable. Now, a little part of this act is pending. Do finish it. Taking 2 minutes pause. Go through with it. If you are having any doubt, do ask. Then we'll proceed further. Is it clear, students?
Sir, writing the notes daily, that is as per our own understanding.
Your own understanding.
For module.
Your own understanding. I just want it to be. I want you to make. I want you to be competent, not copying the module. Okay. Even if you will copy, I would like. What is the sense of then attending the lecture, right? Do write in your own language. Do whatever you have learned from the lecture. Okay. The crux.
And while preparing for the exam and while answering to the questions, are we supposed to like follow your material, or it has to be like in a
I am going to give you one
module-based
more
batch?
material, that is the summary of my lectures. Okay, and I find it like sections I am making you learn in the class itself. And language, if you'll go through 2-3 times while revising, ultimately your answer will depict the language of material only. So you need not to put much hard work on developing the language. It's a matter of reading only. Okay, if you'll go through once or twice my notes now, ultimately your answer will carry those kind of words or terminologies only. Okay, so don't focus on language, that you have to copy the language of study material. That is not at all possible, right? I am going to take oral. Do revise it properly. Okay, coming in. Done, students? Done? Thoroughly? Thoroughly? Thoroughly you have done with revision? Now online students can type an answer and other students may. You explain me about payment of wages act, whatever you have understood till now.
It has to be paid within the day of the next.
What if I am a layman, I am your client, I am just asking you about certain doubts that I am planning to prepare a policy for payment of wages for my employee. How would you guide me as a consultant?
The mode for payment, I'll mention the mode of payment and the deadline for paying the wages.
Don't talk.
Mode of payment and deadline.
Make it as easy as it can be for me. Who want to answer? Nobody. I am an owner of a normal organization, and I'm planning to make a plan on payment of wages to my employee, and you are a labor law consultant. I am asking you that should I consider certain points while making such kind of policies? So how would you guide me?
First, I'll determine what kind of institution or an organization that is, and
Means first of all she'll check whether my organization will come under the definition of industrial establishment or not. If it is not, she would guide me, Rahul, proceed with your own policy, no norms need to be followed, right? And if my organization is not coming is coming under the definition of industrial establishment, she would guide me, wait Rahul, let me draft a policy for you. You're not capable enough to draft because you're not well equipped with payment of wages act, right? Right, students. Second, what you will do?
I will make the definition
she'll guide me with certain elements, right? Certain elements. See, Rahul, if you're paying commissions and it is based on sale, no worries. You can pay the way you want to pay it, right? But if you are paying what special expenses, you can pay it the way you want to pay it, right? But if you are paying these 5 things, please consider that payment has to be released based on my recommendations. Either it would be on 7th or it would be on 10th, or if you are terminating then within 2 working days, or if you are closing down within 2 working days, and you should make sure that payment should be made in
Digital payments.
working days, right? Working days. And along with that, she would even ask where organization's location, right? Because she have to refer the state rules as well, right? She has to refer the state rule as well, because state wise the norms will change when it comes to mode of making the payment. And she would guide me that, Rahul, as this act has been applicable, make sure that you are paying at least monthly wages, right? Not more than monthly, right, students? Is it clear? Now proceeding further with fines, we know what all 10 things are. You are eligible to deduct it out, right? Yes.
The state rule varies from branch to branch, or headquarters is what?
Branch to branch. Because branch, here they are using the term establishment. So a single branch can be classified as an separate establishment, right? Right, students, is it clear? Now 10 things that can be deducted, out of which 2 need to be policy matter and other 8 can be based on actual expenditure, right? Now proceeding further. Now section 8 is very, very important. In the entire chapter, the things that are important is section 5, then section 7, then section 8. Even section 2 mein, the definition of wages is very important, right? Right, students? Now they are saying about section 8, act and omission. Now when the fine will be imposed, beta, if you are doing something or if you are not doing something, right? When the fine can be imposed, if you are doing something which is wrong, right? Or if you are not doing something which ought to be done, right? That is called omission, right? Right, students? Fine can be charged on act or it can be charged on omission. But it is a subject matter of policy. I told you very clearly in the beginning itself. See, here it is written, it need to be pre-notified. It need to be pre-notified. Means it is a subject matter of what? Means you cannot come out with the random fines, right? You cannot come out with the random fines. See, today is Monday, I am going to impose this much fine. Next day is the Tuesday. According to the day, I am going to impose the fine. You cannot do it like that, right? So, fine can be imposed. It need to be pre-notified, right? And it should be according to the state rules. If your state has come out with any fine related rules, you have to follow those rules as well, right? Right, students? And it need to be pre-notified to the employees by virtue of a public notice. Means by virtue of a notice to be attached in the conspicuous place of the organization, right? In the front gate of the organization, right? That in these situations or in these events or omissions, the fine will be imposed. Got my point, students? So what all rules are there for fines? First thing is what? It should be pre-notified, right? Second, it can be due to act or omission. The third thing is what? It need to according to state rules, right? Right, students? And it need to be disclosed in the conspicuous place of the organization. Got my point, students? Is it clear? Now, no fine can be imposed ex parte. Ex parte, you know, na? That is, you are imposing the fine without giving reasonable opportunity of explanation to the employee. Got my point? Means you have to give a show cause notice to the employee. Means no fine can be imposed ex parte. Ex parte means excluding one party for hearing. Got my point, students? Means you have to give a reasonable opportunity of being heard to the employee. Got my point, students? Is it clear? Is it clear? That both the parties should have reasonable opportunity to discuss about imposition of fine. Means if I am imposing a fine on her, I should give a reasonable show cause notice to her that why fine should not be charged. Got my point, students? Is it clear? Now further they are saying that fine limit can be maximum up to 3% of wage period wages. Okay, means if your monthly salary is 10,000, maximum fine for the wage period can be charged would be 300 rupees, right? Right, students? Maximum permissible fine can be how much? 3%. How much fine can be imposed, beta? 3%. Tell me the rules of fine. Which section we are studying? Section 8. Confidently, no? Section 8. What is section 8? Rules related with fines. The first rule is what? Fine can be imposed on act or fine can be imposed on omission. Right? The second rule is it need to be pre-notified by a written notice, not oral notice. Right? You should have an evidence of written notice that notice has been given to the employee. Third, it should be according to the state rules as well. The fourth thing is what? It need to be notified in writing. I told. Right? The next one. You cannot impose a fine without giving a reasonable opportunity of or show cause notice to the employee, right? And the last one is what? Maximum permissible fine for the wage period can be maximum up to 3%, right? How much fine can be charged, beta? 3%, right? Right, students. No fine can be charged on an employee who is having an age under 15. No fine can be charged on an employee whose age is under 15. Is it possible in India? Is it possible in India to employ a minor child? Can you employ a minor child? Can you employ a minor child? Can you appoint a minor? Abhi I am coming back to her question. Do these laws are being complied with actually in real life? Have you seen people who is having an age of less than 18 years working here and there? Have you seen? So how you are saying that that child cannot be employed? Where you will complain? Where you have written that child cannot be employed? Where it has been written, tell me the name of law where it is written that child cannot be employed. What? If you'll go through with Constitution of India, see, if you'll go through with Constitution of India, child labor is restricted over here in India. It is not prohibited. Okay, there is a difference between prohibition and restriction, right? Child labor is restricted. It is not prohibited. You can employ a child for certain category of works. Okay, so a child can be an employee as well. Got my point? It is not required. He need to be an apprentice, right? Right, students? Is it clear? So, what is the first rule of fine? It can be for an act or it can be for an omission. The second thing is what? The third thing is what? It need to be pre-notified in writing. The fourth one is what? Reasonable opportunity of being heard need to be given to the employee. The fifth one is what? Maximum permissible fine can be 3% of wage payable for the wage period, right? And the last one is what? No fine can be imposed on an employee whose age is under 15. It's not 15, it's under 15, right? Right, students, is it clear? Now you cannot recover the fine on installments. What they have written is, you cannot recover the fine, like you are saying that, see, I am charging 10% fine, but I am going to collect 3% in next 3 months and 1% in next month. Will it be possible? No. You cannot impose more than 3%, point number one, and you cannot collect it in installment. Once the fine has been imposed, it needs to be collected within 90 days. Within how many days, beta? Within 90 days. So if being a labor consultant, my client is asking, Rahul, I am just willing to make the disciplinary environment, discipline oriented environment in my organization, and I want my employees to be quite very punctual when it comes to sign into the office, right? So I would suggest, okay, you can do it, but don't charge penalty more than the 3% of their salary, right? If you're charging more penalty or more fine, you would be in a legal trouble, right? Second thing, give them concession period that they can pay the fine within 90 days, no problem, but you cannot recover the fine in installment, like 1% now collecting 1.5% I'll collect in next month. That is not possible. And never charge a fine from an employee if he is below 15 years, right students. Now
So this 3% is after deducting all the deductions or before?
what deductions?
And for example, there is basic salary and all the things.
We have understood the definition of wages is na. So wages definition includes only 5 elements. So sum total of that 5 element ka 3%. Got my point? Wages is defined over there. So whatever is being defined as a wages, it includes 5 things. So sum total of those all things will come under the definition of wages over here. 3% of that wages. Yes. Yeah, that sum total of those 5 amounts. Okay. Is it clear? Got my point? Further, they are saying when the 90 days will be counted, it will be counted on the day of act or omission. Means the fine can be collected within 90 days from the date of act or omission. Whatever day you have committed the wrong, right? It will be treated as fine has been imposed on that day. Is it clear? Is it clear, students? Now further they are saying 2 additional points, which is very normal points. First thing, they are saying that if you have imposed any fine, you have to keep records of all the fines that has been charged and collected. Is it logical, students? Quite logical, right? Right, students? It is quite logical. What you have to do is you have to keep the records of all the fines charged, and whatever fine that has been collected cannot be invested as a capital in the business. You have to spend it for the welfare of the employees. Is it logical? Is it logical? Fine is what? If you are imposing fine, can it be classified as an additional income of organization? How it can be, right? So whatever fine that has been collected, if you are having multiplicity of departments, you have to maintain a common account with a bank. You have to deposit all the fines imposed on employee on that account, and you have to make sure that you are spending that amount for the welfare of the employees. Got my point? So can I say that whatever fine that has been collected by organization cannot be classified as an income for the organization? It need to be collected, records have to be kept, and it need to be separated in a deposited in a separate account, and should be spent only for the welfare of the employees. Everything is quite logical, students, right? So what all are the fines related rules? 5 significant rules are there. The first one is, if you are doing something wrong, you may be subject matter of fine. Fine should be maximum up to 3% of the salary, right? The third thing is, we cannot collect the fine in installment, but can collect within 90 days from the date of imposition. The fourth thing is what? Cannot impose fine on an employee having an age less than 15. Fifth, whatever is being collected will be segregated, cannot be treated as an income of an organization, and should be spent for the welfare of the. Got my point, students? Is it clear? Manageable? Now go through with section 8. Now we'll proceed further. Okay, students? Today being the first lecture, it took so much time, but you understood everything, right? And you learnt everything, sections. Section 2, 3, 4, 5, 6, 7, 8, right? We haven't skipped any section. Now see, an employee is drawing a salary of 10,000. Now the employer has imposed a fine of 500. Can he impose fine of 500? 10,000 ka 3% is what? 3,000, right? Maths aata hai, right? So 3% is what? 300, right? So you can charge maximum up to 300. If you are charging 500, you are charging 2% extra. You would be subject matter of punishment under or penalty under Payment of Wages Act, right? Now all the employees have agreed. My question. Now all the employees have agreed. They are very much committed for discipline, like you all students, right? And they are like, okay sir, whatever fine you want to charge. Even if it would be 20% of my salary, I am okay with that. No problem at all. They have signed a written agreement with the employer. Will that agreement prevail or not? No. Because no agreement can prevail over law, right? Prevail over law. Why you are getting into constitution? Right? Prevail over law. Got my point, students? Is it clear? Now the last portion has to be taught. Go through with section 8, students. Go through with section 8.
We have morning classes also for 3 hours.
Okay. Of which subject?
Company hour.
Okay. So,
We will need some time for revision of that subject also.
see beta, how much time will it take? Tell me to revise my portion. 15 minutes? 15-20 minutes, right? For writing it will take 15-20 minutes, right? So,
For the writing it takes
no,
we need
it
some
won't take.
assignments of-
It won't take. It won't take. You should think that it's for your benefit. It's not for my benefit. You are not a child. Na? I cannot put obligation that you have to do it. But if you'll do it, it will be better for you. Let's.